This case involves two indictments, 55-430, which is in 2020, the indictment that actually went to trial. Then you have 56-788, the 2021, the so-called superseding indictment that never had a trial. Now here's where the problem starts. The jury trial began on October 26, 2021 on the case number 55-430. That is what the trial transcript shows. That is what the court reporter shows. That is what every page of testimony shows. There is no trial transcript for 56-788. No voir dire, no witnesses, no jury instructions, no deliberations, because there was no trial on 56-788. On October 28, 2021, while the jury was still sworn in, the state Nolle 55-430, essentially acquittal, claimed re-indictment in open court, which they never did, yet no arraignment, no reading of a new indictment, no jury reset ever occurred. The jury kept deliberating on 55-430. All right. The jury did not return a verdict on October 29th. The verdict was returned on November 1st, 2021. That is clear from the verdict form, the sentencing timeline, and the court's own record. Now, here's the critical part. The clerk's inventory sheet submitted as part of the appellate record lists a verdict date of October 29, 2021 on the case number 56-788. That entry is a lie. All right, let's be precise. There was no verdict on October 29th. There was no trial on 56-788. The verdict occurred on November the 1st. So when the clerk records October 29th as the verdict date, that is a lie. Backdating the verdict makes it appears that 56-788 had a trial. It conceals that 55-430 was null pros mid-trial. It allows the appellate to rule as if the conviction came from a superseding indictment. But the paperwork doesn't support that story. The Court of Appeals is now referencing events from 55-430 while refusing to receive the full 55-430 record and affirming a conviction on the 56-788, a case that never went to trial. That means the appellate court is speaking outside of the transmitted record. The appellate court is relying on a commingled and backdated file. The Court of Appeals is affirming convictions based on and inferred facts that the jury never found. So let's call it what it is. This is not a harmless clerical error. This is not speculation. A verdict was backdated. A trial was assigned to the wrong indictment. The appellate review is proceeding on an incomplete and altered record. That is procedure over merits. And that's the Georgia Railroad. This is New Media, the Marquine Senior Investigative Analyst, and we are on the Dexter Lee Williams case. We even have reports that Judge Luke Meyer has unofficially resigned. We're going to stay on top of the details of that case because we have not got it in factual stone as of yet. But we're definitely on top of it. Y'all stay with me. Make sure y'all like, share, and follow because this is New Media, where the truth will never be silenced. Be great today. Peace.